We received a letter from Ayie Esperon of Surigao del Norte. According to Ayie, a house and lot is being sold to her. The lot on which the house was built was not registered. The occupant of the property was Mr. ABC. In 1983, Mr. ABC sold a portion of that land to Mrs. XYZ by virtue of a notarized deed of sale. Mrs. XYZ and her husband built a house thereon, and in the 1990s, Mrs. XYZ passed away and left Mr. XYZ and 5 children. When Mr. XYZ recently passed away, the 5 children decided to sell the house and lot. However, one of the 5 siblings works in the Middle East, and spouse and child was left here in the Philippines. Ayie Esperon's questions are as follows. What is the procedure for buying a land? And what documents should she prepare or might be required to submit? Can the heir of Mr. XYZ, who is in the Middle East, execute a document to authorize his spouse to sign for any agreement pertaining to the land? Can Ayie have the land registered under her name under these circumstances? Ayie, the first thing that you should do is to go to the Register of Deeds and check against any encumbrances on the house and lot. It is highly improbable that the land is not titled at all. If the property is not registered in the name of any natural person, then it is possible that the land is owned by the government. Granting that the land is declared owned by the sellers for having stayed there in good faith for more than 30 years, and the government recognizes them as the owners in good faith, then your next step is to make sure that the heirs of Mr. and Mrs. X settle their parents' estate. Supposing that the estate of Mr. and Mrs. XYZ was already settled, then one of the 5 heirs who is in the Middle East may execute a special power of attorney in favor of one of the siblings or his spouse to affix her signature on any pertinent documents. Granting that everything is settled, have a notarized deed of sale prepared. The seller will have to obtain tax clearance certificate from the city treasurer's office where the property is located. They will have to show that realty taxes were paid and updated. Certified true copies of the latest tax declarations must also be obtained. A certified true copy of the latest tax declaration and certificate that says "with improvement" from the city assessor's office. You will then be required to pay documentary stamp tax and capital gains tax for the transfer of real property. It is also required to get a certificate authorizing registration from the BIR once all the necessary taxes and fees have been paid. You will then have to apply for registration with the Register of Deeds. At the Register of Deeds, you will be required to submit a copy of the Deed of Absolute Sale, official receipt evidencing payment of transfer tax, certificate authorizing registration, including receipts for payment of documentary stamp tax and capital gains tax, real property tax clearance from the Office of the City Treasurer, and copy of the original certificate of title. After this, you have to obtain a new tax declaration over the house and lot in your name from the city assessor's office. Finally, Ayie, as a reminder, you must carefully remember that in the case of Karam versus Laureta, the Supreme Court held that the rule of caveat emptor requires the purchaser to be aware of the supposed title of the vendor, and one who buys without checking the vendor's title takes all the risks and losses consequence of such failure. The rule of caveat emptor applies to the purchaser at the sale. It is the lookout of the purchaser to go to the Registry of Deeds to find out the real nature of the right of the seller, the declared owner, in order to discover the strength of his or her title to the property. Be reminded that our opinion is based solely on the information you provided us, and it may change depending on any additional information. You are free to consult a lawyer of your choice regarding your legal concerns. Email us at newscenterptv4@gmail.com. Attorney JJ Jimeno-Atienza for the Rule of Law.